Welcome to the NC Injury Rights Podcast.
Welcome back to the North Carolina Injury Rights Podcast with Mehta and Jason McConnell, where we break down workers' compensation issues for North Carolina workers injured on the job. Vero and Jason are co-founders of Mehta and McConnell, PLLC, a Charlotte-based law firm focused on representing injured workers across the state. Both began their careers representing employers and insurance companies before shifting their focus to helping injured workers understand how the system actually works. I'm your host, Evan Mack, and today we're talking about why workers' compensation claims get denied in North Carolina and what injured workers should know when that happens. Gentlemen, welcome back.
Thanks, Evan.
All right, so right out the gate, when a workers' compensation claim is denied in North Carolina, what are the most common reasons behind that decision?
Well, Evan, I think there are probably two main reasons that they're denied that I see. In North Carolina, the law allows insurance companies to deny a claim for any reasonable basis, although reasonable basis is not really defined very well. I would say the most obvious reason that insurance companies deny a claim is the no injury by accident, which is the standard for a workers' compensation claim in North Carolina. And oftentimes when employees are reporting their incidents to work, they may be afraid that if they say that something unusual or they were doing something different than they normally do that caused an accident, that they could be disciplined for that. So they'll try to minimize kind of the incident or non-specific thing that they were doing that caused their accident. So that's usually the first one. The second most common thing that I see is that while there may have been an incident, it was not significant enough to cause the injury that the employee is complaining of. So insurance companies and employers will minimize the accident that led to the injury. Or they'll accept, he may have strained his back, but it couldn't have caused, a herniated disc or something that significant. So those are probably the two main reasons that cases get denied in North Carolina.
So Vero, like, how often do denials come down to paperwork issues or those missed deadlines? Which deadlines tend to cause the biggest problems in your experience?
That's a good question, Evan. There are deadlines in North Carolina for when an injured worker needs to report their injury to their employer, how quickly, as well as a deadline for how soon an injured worker must file a claim with the Industrial Commission. There's case law with exceptions and things, but to simplify it for our listeners, an injured worker definitely wants to file a claim with the North Carolina Industrial Commission within 30 days of the incident. If they fail to do so, if they fail to provide notice, that can be basis for denial of a claim. Other times when paperwork or missed deadlines can possibly arise is if an injured worker has filed a claim, has notified the insurance company they were hurt at work, and the adjuster's trying to reach out to them to either take a recorded statement or for whatever reason needs their medical records because they can't get them on their own, and the injured worker's not responding. That can also give the insurance company reasonable grounds to deny a case.
So Jason, how do disputes over whether an injury is truly, work-related factor into the claim denials?
That's a good question also. I would say that more often than not, insurance companies, if they have a reason to suspect that the incident didn't occur at work or wasn't as significant as the employee is claiming, they're going to deny the claim. I think insurance companies' default setting is denial. And then based upon the information that the employee gives to their employer, whether it's their supervisor or HR, and that's another important distinction to make as well. Oftentimes, employees will suffer an incident at work. They'll tell their supervisor and assume that the supervisor will then, run that up the chain of command to HR and things like that. When in reality, most supervisors are more focused on making sure that whatever section that they're responsible for is running the way it's supposed to and meeting its production requirements and things like that. So an injured worker is oftentimes a hurdle to that. So they're not as focused on that as opposed to, making sure that the fact that an employee suffered an injury on the job doesn't stop the process that they're responsible for. So I always tell workers, if you get hurt on the job, it's great to tell your supervisor, but the telling the supervisor should be the first step to you then going to HR and reporting it there, because that's the entity that's really responsible for documenting these things and making sure that it's reported to the insurance company, that adjuster reaches out to the injured worker and sends them for the appropriate medical treatment and really starts the process of having a workers' compensation claim. It's typically not just the injured worker's immediate supervisor.
But Vera, what about this though? A lot of workers hear that their injury is being labeled that pre-existing condition. How does that come up in a workers' compensation case? How does that affect eligibility and for benefits?
You'll definitely, Evan, see insurance companies try to use pre-existing conditions as a reason to deny cases. It's important for injured workers to know that an injured worker can have a pre-existing condition, but still have a compensable workers' compensation claim. If a pre-existing condition is materially aggravated or worsened by a work injury, that is sufficient to have a compensable claim. Of course, the insurance company won't tell you this, and the burden is uh, with the injured worker to establish that material aggravation. And that is where an experienced workers' compensation lawyer can certainly counsel an injured worker through a process and help them obtain the necessary supporting evidence to show that even if they had a pre-existing condition, it was materially aggravated due to their work-related injury by accident.
Hmm. So what role does medical evidence play in denial, and where do the injured workers tend to run into trouble with medical documentation or maybe that treatment history?
So the first place that most employers will send an injured worker is an urgent care facility like a Concentra or a FastMed. And what the injured worker should understand is A, they're not seeing a specialist. And B, they're going to a facility that has a relationship with the insurance company. So that relationship in and of itself is working against the injured employee. The second thing I would say, oftentimes injured workers, and I think this is just people in general, tend to minimize the severity of their injuries. They don't want to look like they're complaining or, making more out of an incident than perhaps there may have been. So they tend to downplay, their own pain and suffering. I would tell people, you need to advocate for yourself, because the insurance company is definitely going to have someone advocating for them. Like I said, they've already got relationships with Concentra and FastMed and those urgent care facilities. Those facilities are receiving payment from the insurance companies, so they know it's in their best interest to kind of do what the insurance companies want them to do. Typically, Concentra will not write an employee fully out of work. They will assign some type of work restrictions, even if it's a fairly significant injury. And the reason for that is it will allow the employer an opportunity to find some type of modified duty position to bring that worker back to work, so the insurance company doesn't have to begin paying weekly compensation. So I would just tell a worker, when you go to a medical facility, whether it's an urgent care, an emergency room, or even if it's your own primary care physician, make sure you advocate for yourself, that you really give them a good picture of the extent of your injuries, the discomfort and pain that it's causing you, the limitations you have as a result of that. Because if you don't do that, then no one else will.
What about those inconsistencies, Vero, in what an injured worker says, whether it's to his employer, a doctor, insurance adjuster, how end up being used as a reason to deny that claim?
Credibility can always be used by an insurance company to deny a case. We've talked about other reasons for denials in this podcast, but an insurance company can say that we don't believe this injured worker is credible. Okay. And we don't believe that they can credibly establish in a court of law by the preponderance of the evidence that they sustained a compensable injury by accident arising out of in the course of their employment. And so they can use these inconsistencies um, to support their denial. So if an injured worker tells their supervisor one description of how the event happened, how the accident happened right after it happened. And then the next morning they come in and human resources asks them to fill out an incident report and they say something different in the incident report. Or like you said, they say something different to a medical provider, or they say something different in a record statement. Um, the insurance company will use these differing descriptions to say, you know, we don't really even know what happened. We don't know if this injured worker can credibly describe what happened, whether their injuries are even related to work or some, other pre-existing stuff that may be, documented in the medical records that the insurance company gets. So it is very important, um, like Jason said, to be an advocate for yourself, to give clear, thorough descriptions, but also uh, consistent descriptions uh, to the various people you talk to after an injury.
So once a worker receives a denial letter, what are the most important next steps to take, and what mistakes tend to, make the situation worse?
If your claim is denied, that's really when you need to seek the advice of an attorney. Um, Most injured workers are unaware of how to pursue a workers' compensation claim in North Carolina. The first thing that should happen is the employer is required to file uh, a form with the North Carolina Industrial Commission documenting the incident, when it occurred, things like that. But they also are required to provide what's called a Form 18 notice of accident to employer and claim of employee to the employee. That's the form that actually uh, the injured worker uses to file their claim with the North Carolina Industrial Commission. Um, in North Carolina, all workers' compensation claims fall under the jurisdiction of the North Carolina Industrial Commission. That's the administrative body that handles and oversees all workers' compensation claims in North Carolina. And to initiate a claim, you actually have to file that Form 18 with them. It's important that the employee understand that if they fill that form out incorrectly, if they don't really describe an injury by accident on that form, it's only going to strengthen the denial of the insurance company as the claim proceeds. So really, they need to speak with an attorney that can advise them on how to process and how to file a claim. Can even complete those forms and file them for them electronically with the Industrial Commission, and make sure that the claim is initiated um, properly and gives the best information to get that denial overturned at some point. Whether the insurance company, once they've seen additional evidence, decides to accept the claim on their own, or whether you have to proceed to the hearing or trial phase in a workers' compensation case.
Mhm. So, Vero, at what point does having a workers' compensation attorney become especially important after denial? What parts of the process are hardest to fix, by yourself or, maybe without help?
Yeah, well, as an aside, Evan, Jason, I would strongly advise anyone going through this process to talk to an attorney before giving that recorded statement, before filling out that, written statement that could get your case denied. Oftentimes, it didn't, an attorney can help a case from being denied. That being said, to directly answer your question, after a case is denied, you know, certainly you can try to submit more evidence and argue with the insurance company. But I mean, I don't even think I've had a handful of cases throughout my 16-year career where an insurance company changes their mind. Once your case is denied, it's likely it's going to stay denied, and the insurance company is not going to say, "Oh, you know what? On second thought, let's go ahead and accept your case." Okay, so you're going to need an attorney at this point to counsel you and represent you through the litigation process. Once a case is denied, you're going to have to appeal the denial. Uh, the insurance company will likely hire an attorney to represent the employer and the insurance company. There will be a discovery process, okay, and then unrepresented uh, injured workers struggle with discovery because these are legal processes, okay, that require expertise and experience, and it's very hard. It's not impossible. It's very hard for an unrepresented injured worker to be able to uh, thoroughly complete this process. So a workers' compensation attorney helps with that. Like Jason said, a workers' compensation attorney oftentimes can help, again, part of the discovery process, compile evidence that could support challenging the insurance company's denial, whether that's factual evidence such as photographs, witness statements, things like that, or medical evidence that, for example, does show that a pre-existing condition was in fact materially aggravated. An attorney can help with that. And then a denied case will most likely go to a mandatory mediation where an attorney can help counsel the injured worker through the mediation, represent them, and help negotiate a settlement to their case. If a settlement is not possible, if the insurance company does not make a fair offer, then the final step in the workers' compensation case is it will go to a full evidentiary hearing where a one-person deputy commissioner will decide whether the injured worker or the insurance company wins the case.
Hmm. Yeah, and fellas, before we close it out, for someone listening who's already dealing with a denied claim, what tends to matter most in keeping that, that case moving forward rather than get stuck or, giving up?
Well, in a denied case, the first thing you're going to want to do is file what's called a Form 33 request for hearing. That's what actually propels the case forward. A couple things are going to happen at that point, and it's important for employees and injured workers to understand that, unfortunately, the workers' compensation process is time intensive. I mean, these claims tend to take months, to even years, sometimes before they're fully, completely resolved. So the faster you do things on the front end, the more it moves the case forward. So once you get the denial letter, if you have not already retained an attorney, it's very important that you speak with an attorney, retain someone to represent your interests so they can go ahead and file that request for hearing. Because once that's filed, it's going to trigger the claim to be moved to the mediation process, where the parties will actually sit down with a neutral third party mediator and the opposing party and attempt to resolve the claim, or at least the disputes that have given rise to the filing of the Form 33. And if that's unsuccessful, then a month or so after the mediation, the claim will be put on a hearing docket and heard before a deputy commissioner of the North Carolina Industrial Commission. All this takes time, and employees are often frustrated in the amount of time it takes, especially in a denied claim. If they're not working and they're not receiving income, part of the insurance company's strategy is to hopefully starve these individuals out and get them to settle their cases on, a denied basis for, pennies on the dollar to what the actual value may be. But they know that, someone who doesn't have an income, who may be living, week to week or month to month or paycheck to paycheck, it's going to be difficult for them to outlast the workers' compensation process. So the sooner you get an attorney involved, get that Form 33 filed, and initiate the hearing process and the mediation process, the more quickly your claim is going to move towards resolution, whether that be through a settlement or whether it's going to a hearing and getting a decision from a deputy commissioner.
Amazing. Gentlemen, thank you so much for your time.
Thank you, Evan.
Thanks, Evan.
All right, guys, that wraps up today's episode of the North Carolina Injury Rights Podcast. If your workers' compensation claim has been denied and you want to better understand your options under North Carolina law, you can visit McConnell.com to find more information and resources from attorneys Vero Mehta and Jason McConnell. Thanks for listening, and don't forget to leave a review, subscribe to the show so you do not miss the next episode. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.